today with our team. We have our three excellent officers here. We've got Jenny Baldridge, Jennifer Ramirez, and Jared Dodson. So I've really enjoyed working with them since April. I'm new to this, so I've gotten to know a lot of y'all, but I've really gotten to enjoy working with them and come to love them. I think you will too. So if you haven't closed something with us yet, we would love to serve you from our new location over in Ashland Park. And yeah, we've got great underwriters like Old Republic, Alicia, who's presenting this class today, and a great center like Lucy Room, and also presenting this for having us. So thank y'all for coming and y'all enjoy your music.
I was about to say good afternoon, but we're still morning, even though you're enjoying lunch. Well, thank you all for attending today, and thank you to Truly Title for putting this class together on foreclosures. My name is Alicia Baugh, and I'm here presenting on behalf of Truly Title. Share with you a bit about foreclosures. We're going to see some terminology and talk about the different types of foreclosures, and also look at requirements and processes related to foreclosures. I am not an attorney. I do work for an underwriter that writes policies on Old Republic, and so I just want to get that out of the way. If I can't answer a question that you have, I will find the answer for you and get back to you on that, or get back to Hannah and her team so that they can help you out with any questions that I might not be able to answer. So the other thing I wanted to mention before we get started is if you are attending this class for credit, please make sure that you've signed the roster, including your name exactly as it's shown on your license and your license number. And I'll have credits posted probably by no later than Friday. So if anybody needs a credit posted sooner than that, let me know, or let Hannah know, and we'll get that taken care of. I think that's it. So we've got a QR code here for you to utilize with your mobile device. You can pull the PowerPoint PDF and then save that to wherever you would like, in addition to any handout that was provided today. And then at the end of the presentation, if you would do me a favor, Trek likes to know how their instructors are doing out here on the road. And so if you'll complete the evaluation form that's been provided to you and just leave that on the table, or hand those over to Hannah, then we'll get those submitted onto Trek as well. Okay, so let's go ahead and get started. I just added this morning before I headed over, just because foreclosures aren't fun. What we're going to be talking about today isn't fun, so I thought I would add a little comic. Sorry, it's not provided in your in the handout that you'll download. It just says here, the people over to the left are talking to the igloo owner and saying, "You're 3 months behind on your mortgage payments. I'm afraid we're going to have to melt your igloo." So I'm not a joke teller, sorry. That's the best I got. So, all right, before we even dive in, I think it's important to look at a definition of foreclosure. Very sweet and simple. It's a legal process that occurs when you're unable to continue making your mortgage payments, and as a result, you forfeit your rights to the home. So the bank or lender will take over ownership of your property. And I think we all know the old adage, if you don't pay, you don't stay. So that's basically sums up foreclosure. Now, forbearance is different. And so forbearance is a pause in mortgage payments that's intended to help a person avoid foreclosure. And unfortunately, we are still going to talk about the COVID-19 pandemic in this presentation. It's very important with the last couple of years that we've gone through that we still talk about that. And so one thing I'll note here is there were no late fees or penalties charged in connection with any COVID-19 related forbearance. And foreclosure rates coming out of the pandemic are still pretty low. They were very low during the pandemic because there were moratoriums that were put into place. The CARES Act had, that effect. There were federal moratoriums as well as state moratoriums, and there were extensions for each of those. All of which have expired at this point in time. But the other factors that related to low foreclosures and still continue on to contribute to low foreclosures would include the CFPB, or our Consumer Financial Protection Bureau, as well as high equity that folks have in their homes. So foreclosure activity across the U.S. continues, a slight climb. And of course, with all economists, we're not able to, tell you whether or not we're looking at, a large rise in foreclosures in the months or years to come. But they are, at a climb, but they're still, I believe, lower than pre-pandemic levels. At the end of 2022, rates were low comparatively to pre-COVID levels. However, it's been reported that we are still going to see a little bit of a year-over-year percentage increase. Texas was among one of the states that saw the greatest number of foreclosures in the first part of 2023 at just over 14,000. And according to SoFi, the Lone Star State withstood 2,288 foreclosures in June of 2023, with a foreclosure rate of 1 in every 4,997 households. So this puts Texas as the second most populous state in the U.S. at a whopping 11,433,880 housing units, and so puts us in the 24th place. We're second largest state in the union, 24th place as far as foreclosures go at this point. All right, so let's talk about the CARES Act. Enacted by Congress in March of 2020, the CARES Act provided financial relief due to the COVID virus pandemic, and was intended to assist Americans who were dealing with the economic crisis. Many of you may have worked with sellers even that took refuge under the act. It provided for a moratorium on foreclosures involving federally backed mortgages for initially 60 days, but that provision was extended several times by individual agencies as the pandemic continued. But it was finally, the CARES Act finally, the moratorium was finally expired in July 2021. Now, the CARES Act applied to federally backed mortgages and on 1 to 4 family homes that were insured or guaranteed by VA, FHA, USDA, or loans that were owned by or securitized by Fannie Mae or Freddie Mac. It didn't apply to any abandoned homes or vacant properties or private bank loans. So realistically, we're looking at about 80% of all loans being affected by the CARES Act. And under the act, unless it was a vacant or abandoned property, lenders during that moratorium could not initiate any judicial or non-judicial foreclosures. And we'll see the difference in those here in a minute. They also couldn't file for a motion for foreclosure judgment or any order of sale. And then finally, they weren't able to execute a foreclosure related to an eviction or sale. And so although these moratoriums have expired federally and on the state level, the between the CARES Act moratorium and the state moratoriums, COVID-19 is the gift that keeps on giving. And when I say the gift. It's actually a penalty that relates to what we do in the title industry because of all of the things that we have to look at when we're reviewing foreclosures. There's already, a multitude of things, deadlines, time frames, filings, notices, the different parties that are involved that we have to take into account when we're reviewing properties that have been foreclosed on. But just as we saw on the last slide, or I don't think I put it in the slide, sorry, what I was saying about the restrictions as far as foreclosures were concerned during the moratoriums, those different restrictions, we've got to look at those as well. The time frames, and if we're dealing with multiple, other states, we're having to look at when those moratoriums, were still in place and different things related to that. So, okay. So the Consumer Financial Protection Bureau, the CFPB, rules issued by them effective August 31st of 2021 established some temporary special safeguards to help ensure that borrowers would have time before foreclosure to explore their options, including loan modifications, and then if it made sense to finally sell their homes. The rule covered loans on principal residences and generally excluded small servicers. Now, forbearance doesn't erase the amount that you owe on your mortgage. It's just a pause. And so any missed payments or reduced payments have to finally be paid. Forbearance is just a temporary solution. And so there's generally three options when it comes to forbearance that persons definitely sought refuge under in the last few years. And so one of those was a deferral. And so those were pause payments that were added to the end of the mortgage. It extended the term, and those paused payments, those amounts were added up and possibly will be a balloon payment. There's no additional interest, penalties, or anything like that when it came to any forbearance that was done under while the moratoriums were in place. Also, one of the other options for forbearance was lowering monthly payments. So this would be where homeowners would look at a loan modification. And so it would change interest rate, principal balance, the length of the mortgage. And then finally, for homeowners with sufficient equity, then selling their home might have been the best option for them. Let's see. I know there was something else I wanted to mention here. So clients that are looking at forbearance options will often, maybe if you have someone, a customer who has been in forbearance or has even been in talks with lender before they go into foreclosure, if they're behind on their payments, they'll often report that they've been in communications with the lender and that they're making plans and, it's all going to be worked out. They've got phone calls. They maybe even have some messages that they can show you. But unless it's in writing, phone calls, these messages don't mean anything. So just make for sure that you're listening to your customers whenever they're talking to you about if they're behind or anything, if they're making any claims that they've received forbearance or anything like that. Just make sure that you're confirming, what they're providing so that you don't get to the point or, while we're during the pendency of the contract, they actually, fall into that foreclosure or, some sort of place where they're not able to continue with whatever program they think that they've, secured. Now, when foreclosure is unavoidable, in some cases, foreclosures were unavoidable. And so under CFPB's rules, foreclosures could start, and we're still talking back in pandemic, if the borrower had abandoned the property was more than 120 days behind on their mortgage before the shutdown, was more than 100 days behind on their mortgage payments and hadn't responded to specific required outreach from a mortgage service provider for 90 days, or they had been evaluated for all options other than foreclosure, and there were no other available options to avoid foreclosure. CFPB is going to be around for quite some time. I know there were some reports at one point that, things that they were doing, folks were thinking that they weren't, going to continue, but they are, and they've done some really good things. They took action definitely during the pandemic to help consumers. And so they created an online housing hub website that's still up in partnership with other federal agencies to connect homeowners, renters, federal agencies, and with information on the CARES Act and assistance and programs. They created and established homeowner outreach materials. They continue to closely monitor performance of mortgage service providers to prevent avoidable foreclosures. That's one of their main goals, is to prevent foreclosures. And so one of the things that they're doing is monitoring consumer complaints against lenders. And when they find those complaints, they're reaching out to lenders, and no lender or mortgage servicer wants to hear from CFPB. They don't want to be under their magnifying glass. So hopefully, that action, the things that they're doing is having an effect on the way lenders and mortgage servicers are taking care of their customers. Now, the most important thing for a property owner to do when they're having trouble paying for their mortgage, take control. Do something. Don't just stick their head in the sand and expect nothing's going to happen. And so taking control means making a phone call. That's going to be the best first step. Making that phone call to their mortgage servicer or lender and talking to them about what the issue is and looking for a solution. The other is to accept phone calls from these lenders or service providers. Don't just hope they'll quit calling or lose the phone number or whatever. So just keep these things in mind if you're visiting with a customer that may be having trouble. Make sure that they're keeping in touch with their lender or mortgage servicer. And ask for expert help. There's local counseling services that they could reach out to work out maybe a tailored action plan with their mortgage servicer. They need to be aware of scammers as well. Anyone who's making promises that seem too good to be true, you won't lose your home or different things like that. Those are things that a scammer will probably say. They're also looking for an upfront payment request, or even telling the homeowner to quit making their mortgage payments. So maybe they have an ulterior motive. I don't know, but just make sure that your folks are aware of scams that these folks are doing. Also, just having them, sign over their title directly to that person who's saying they're going to help. And then asking for help, applying for help. There's a Texas Homeowner Assistance Fund it's being overseen by the Texas Department of Housing and Community Affairs, and it comes under the what did we call it? Sorry, give me just a second. The American Rescue Plan of 2021. Sorry, that was so easy to remember. So, apply for help with, an assistance fund such as that. And then, of course, any kind of loss mitigation services that the lender can can help the person with. All right, so other terminology. Let's move on and talk about a lien. So a lien is a claim or charge on the property of an individual, a property that's owned by an individual, to provide security for the payment of a debt, obligation, or duty. And so most of what we see are voluntary liens. A voluntary lien is a consensual lien. It's one that's contractual, meaning the lien is created by an action taken by an individual owner of property. And so it could include your purchase money lien, a home equity loan, a construction loan if you're putting in a new pool or you're making some improvements to your home. All of these are contractual and consensual. But then there's also involuntary liens, ones we don't want to see in the title search, because then we're going to have to call up the folks and let them know what we found, and they're not going to be happy. Although they may already know about it, they may think that we might miss it. But involuntary liens are non-consensual claims that are liens against the property that attach and have to be paid prior to closing. So this could be a lien for non-payment of property taxes, federal tax lien, judgments, maybe even a mechanics lien affidavit, child support lien. And so we're, searching, the title company is searching for all of these types of liens in our title examination process and watching for time frames, when a particular lien was filed. I've said it before, first in time is first in line. So the first lien that we find against a property, that's the one that has the priority. And as we're going during the search process, we're continuing on to search all the way up until the day before the day of closing to close the gap period, make for sure nothing else has been filed of record. All right, so for foreclosure to be triggered, there is a default. So if the debt secured by a lien is not paid, the holder of the lien can foreclose the lien and take the borrower's property to satisfy the debt. Non-compliance with other terms of the lien agreement can also result in foreclosure. So not just non-payment, but maybe letting your homeowner insurance lapse or not paying your property taxes. Different things like that can be a non-compliance. Or selling of the property while the debt is still outstanding. Remember that due on sale clause. So in order to determine if there has been a default, the loan documents, the note, the deed of trust, loan agreement, all of those have to be reviewed. And we would examine those carefully whenever we're reviewing a foreclosure file. To make for sure that the default was there, that all of the rules and processes were followed during the foreclosure process. It's important to note that with a foreclosure, the first notice of foreclosure filing cannot occur until a person is more than 120 days behind on their mortgage payment. So if you've got someone that falls in that category, maybe they're just right at the cusp. If they reach out to their lender for timely help, if they reach out timely for help, an application, a workout plan, the foreclosure can't start until, that process has been gone through. And if they can't, figure out a way to work out, then foreclosure proceedings can proceed. Otherwise, hopefully they've done a workout plan and gotten to where they can do some sort of modification to keep from going under the foreclosure. Now, there's different types of foreclosures, and so we'll talk about each of these as we go through the rest of the presentation. And the first one is non-judicial. And so that means that there's no court involvement. Non-judicial is no court. So liens such as a deed of trust, a purchase money, a deed of trust that we see, pretty much every file that you guys turn in, there's not going to be any court action on those. And governed by the Texas Property Code Section 51, foreclosures are held on the first Tuesday of every month between 10 and 4, usually in the area of the county courthouse. And also, the reason why this is non-judicial or no court action is there's a power of sale granted in these purchase money deeds of trust. And so that allows the lender to foreclose on the property and sell the property at foreclosure. Now, most others are foreclosed judicially, and so this means that there is court involvement, there is court action that will need to be taken, and so that's going to mean that there will be attorneys involved along with the court, and so that could be many attorneys, and so those are going to be more timely and probably more costly as well. We don't have any attorneys in the room, right? I'm not talking trash. I'm just saying, because there's going to be attorneys involved. It may be more expensive and take more time. Examples of judicial foreclosure would be maybe a tax, ad valorem tax sale or an abstract of judgment. Those would be ones that would be in the judicial foreclosure. Now, there's also what's called a hybrid. So that would mean that both types of foreclosure would exist. And so a home equity loan or a reverse mortgage loan is one that would be the hybrid of the two types of foreclosures. All right, so the non-judicial foreclosure. Now let's first just remember that a deed of trust is given to secure a repayment of a debt. It's evidenced by the note. The borrower signs the deed of trust, granting the lender with a security interest in the property that's pledged as collateral. They promise that they're going to pay and keep the property maintained and maintain insurance and pay taxes. And then when they finally make that last payment, the lender will provide a release of lien, right? That's the normal way, best way that it's going to happen. But in the event of default, then the lender will foreclose on the lien that was created under that deed of trust. And so again, the foreclosure is triggered by a default, failure to make payment, non-payment of taxes, or failure to maintain insurance. And the way they'll do this is via the power of sale included in the deed of trust. There's always a trustee that's listed in the deed of trust. And so that's the person, the independent party, that will handle the foreclosure process if the loan does go into default. So sometimes this can be a title company, it can be an attorney, but most often it's a company whose sole purpose is to handle non-judicial foreclosures. And a foreclosure is valid as long as all the requirements set forth in a deed of trust and applicable Texas laws complied with. And so aren't you glad you have your title company that's going to be looking for all of those things, making sure that all the rules and laws were complied with. And so that's why we trust Truly Title. I always find a way to get a plug in there. All right, so any conflicts between the two, a conflict between the deed of trust and Texas law, those have to be resolved or complied with. Otherwise, Texas statutes or case law will control. All right, once the borrower has defaulted, the lender may declare the full amount of the loan due and payable under the provisions of the deed of trust's acceleration clause. Without which the lender wouldn't be able to foreclose or could only foreclose on just the missed payments, not the entire unpaid balance. So if a loan is secured on a residential property, the lender must give the homeowner 20 days written notice. And that written notice must be, or should be, best practice is certified mail return receipt requested. And so that written notice will give them the notice of default and the opportunity to cure. So 20 days. Keep in mind too, for that mailing, the debtor, pursuant to the terms of the deed of trust, is required to keep the lender apprised of their current mailing address. And so normally a lender, if they have reason to believe the debtor has left the home or they might have another address, they're going to send, certified copies to all known addresses. Additionally, if there's a husband and wife that are when there's always a husband and wife on the deed of trust if it's a married couple, to perfect the lien of the lender against both spouses, but those letters will be sent independently. The one will go to the husband, one will go to the wife. All right, so that's the first time period. So we've got that first 20-day notice, the notice of default and intent to accelerate. And then if the debtor catches up, maybe we've got a reinstatement, modification, all fine and good. But if not, then the cure period has passed and now we've got a notice of acceleration and posting for foreclosure. That must also be sent to the residential homestead borrower at least 21 days prior to the foreclosure date. So we've got 20 days, then we've got 21 days at least. And so that's separate. And then there also needs to be a separate notice of foreclosure. The notice is entitled Notice of Trustee's Sale or Notice of Substitute Trustee's Sale. And this notice will provide information about the debt, the legal description of the property, and the location of the sale, the time, the date. And so all of this it's mailed, it's going to be posted at the courthouse, or there's some companies that have foreclosure and filing services that they'll have those posted. And then, of course, the notice or any assignment from trustee to substitute trustee will be recorded in the real property records. So after accelerating the note, then the lender requires the trustee to foreclose the lien on the property in strict compliance with the Texas Property Code, Section 51, and under the provisions of the deed of trust. So the net effect of that 20 days at least and then 21 days is there's currently a minimum of 41 days. And this is after the period of time that the missed payments, I think I've said it was 120 days. So 41 days minimum before a residential homestead property can be foreclosed upon non-judicially in Texas. Now, if there's a deceased party, these notices may be given to an independent executor, maybe an administrator of the estate, or all the debtor's heirs. Okay, so service is completed. It's completed upon deposit in the postal box, or and so it's not upon receipt. It's not for the green card. It's upon deposit into the mail, addressed to the debtor at their last known address. And then the time and location of the sale, it must begin within 3 hours of the time stated in the notice, the foreclosure sale. Foreclosure property is as is, so it's at the purchaser's own risk without any expressed or implied warranties and non-insurable under a title insurance policy. And if there's a deficiency judgment, meaning that if the property was sold and it didn't make up the full balance, then there can be a deficiency judgment filed against the debtor as well. The lender can pursue the debtor for that deficiency judgment, but it must be, that action must be brought within 2 years of the foreclosure sale. Now, we will not insure the buyer at foreclosure sale, but we will insure at a subsequent sale or purchase and sale with a warranty deed. And then there's, different types of liens that can be affected by foreclosure. There's superior liens that can be out there that will survive. The interest will survive a foreclosure. And so, you've got an investor who's out there looking at foreclosure properties. They better know their stuff. They need to be talking to an attorney or maybe pulling a preliminary title report because they need to know that there might be some superior interest still out there that they're going to be taking the property subject to. There's junior liens that are may be wiped out pursuant to the foreclosure process. So we've got maybe a first and second lien. The second lien holder doesn't have to be notified of that pending foreclosure, and their lien could be wiped out. Now, if the sale occurs or is for more than what's due on the first lien, they can then pay the junior lien or the second lien holder for any amount over and above. There's some superior liens that we have in the title industry. We have kind of a chart that our examiners utilize whenever we're looking at liens that are superior or priority or sometimes called super priority. And so we're going to be looking at those as we review the foreclosure file, mark ones off that aren't effective or take exception to if it was something that survived the foreclosure and now we're going into that foreclosing lender selling to the next owner. And so we'll be looking at those and making calls as they come about. Mechanics and materialmen's liens. So I don't know if you've worked much with construction persons who are buying a lot and constructing at the same time. We often call those a one-time close construction. It's very important to the title company that we know that there hasn't been any work performed on the property prior to our closing. There hasn't been any materials that have been delivered to the property prior to our closing and ensuring title. And if there has, we have a problem because of these priority issues. If there's property that has been delivered, then that if they later default on the loan and there were some materials that were delivered and maybe the construction persons weren't, or the contractor wasn't paid for, they could have filed a lien prior to our closing. If we didn't find it, that's something that could be a priority over and above the first lien mortgage that we're insuring. And so one of the things that we have an agent or a buyer or owner of property sign prior to a construction is an affidavit of commencement. And it's just saying that no work has been performed, no materials have been delivered, no dirt has been moved whatsoever. And then we can close, record, and then after that, then they can commence construction. All right, some more priority issues, just trying to get through those real quickly before we move on. So the IRS code section 7425D1 provides that if notice of a federal tax lien was filed in the official public records for more than 30 days prior to a foreclosure sale, the IRS must be given 25 days notice, certified mail return receipt requested, of a foreclosure. So that's going to be a priority if that federal tax lien has been filed prior to that foreclosure, 30 days prior to that foreclosure. If the notice is not provided to the IRS, then the federal tax lien will survive. And so those are just time frames, that we're looking for in the title office when we're reviewing a foreclosure foreclosure file. If notice was properly given to the IRS, then their federal tax lien survives 120 days after the foreclosure in the form of a right of redemption. So they could take the property and recover, any part of their lien. So the successful bidder in an IRS liened property is therefore really not entitled to breathe a sigh of relief until after that 121st day. Federal abstracts of judgment. This has priority over any other lien or encumbrance, which is perfected later in time, but may be superior in any subsequently created mortgage, including a purchase money deed of trust. So definitely, another priority issue that we see in reviewing foreclosure files. Also, first in time, first in line, talking about a federal lien securing payment of criminal fine restitution. So that's going to be based on the recording date in the official public records. A Texas Workforce Commission lien is superior to all other liens except for ad valorem tax liens. That's your annual property tax. So TWC is superior to all other liens except for property tax liens. And then municipal liens. Those are ones that are related to the condition of the property. They're going to have priority regardless of recording date. So those are mowing liens, paving liens, weed liens, and then deeds of trust liens for securing payment of ad valorem taxes. And we're going to talk about those here in a little bit too. Okay, so you'll remember the home equity foreclosure. That's going to be the hybrid. So we'll have both the judicial and non-judicial. A court order, pursuant to the Texas Constitution, a court order must be obtained in order for a home equity loan to be foreclosed upon. So that's why it's going to have that judicial factor, because we have to have the court order, so court involvement. And then the Texas Rules of Civil Procedure, Rules 735 and 736, set forth requirements for carrying out the Constitution requirements. So there are methods for foreclosure under 735 rule. 3 methods will be a suit seeking the judicial foreclosure, a suit or counterclaim seeking a final judgment, which includes an order allowing foreclosure under the terms of the security instrument and the Texas Property Code section 51.002, or an application under Rule 736 that we're about to talk about. So an application under Rule 736 for an order allowing foreclosure. Of the 3 methods, the Rule 736 is going to be the most common. So the home equity deed of trust is reviewed to establish that it complies with the Texas Constitution by disclosing that it was given to secure a home equity loan. And I know whenever I was closing, I remember the home equity paperwork was the largest stack of paperwork we would ever see whenever we were closing. And it had so many disclosures talking about how it was a home equity loan and created under the section of the Constitution that's shown within those documents. So first have to be reviewed to make for sure that it does comply with the Texas Constitution and given to secure the home equity loan. And then an application for court order to sell must include, in part, that a debt exists, a debt is secured by a lien that was created under the Texas Constitution, a default exists, and then the applicant must describe the facts which establish the existence of the default and state that the applicant seeks a court order to sell under the terms of the deed of trust or security instrument, and the Texas Property Code. So that's the first part, applying for that order. And then notice. Allow for time for response. And the deadline for response by the debtor is on or before the first Monday after the expiration of 38 days after a mailing, not counting the date of mailing. So we're looking at all of that. We're going to require, evidence of the mailing, the dates, and all of that when it was deposited with the U.S. Postal. And then if there's no response, then the court can grant the application on a default basis. Default meaning the debtor has defaulted in any sort of response. Now, if there is a response, the court is to hear the application within 10 days, and then finally the order can be granted and filed in the official public records. So the order will then allow the applicant or the lien holder to proceed with the non-judicial foreclosure. So we've gone through the judicial process. Now we're able to go through the non-judicial foreclosure. Reverse mortgages are much the same, so I'm not going to go through all of that. And a foreclosure on a reverse mortgage could occur because of the death of the debtor or all the borrowers being deceased, or maybe the homestead or property was otherwise sold or transferred. And then if that's the case, no court order is required. They're able to move forward with the foreclosure just like any other deed of trust. All right, now property taxes. Property taxes are assessed, of course, on our property every year. We love that. Love to pay taxes. Come on, everyone. So they're assessed every year. It's not something that there's a lien that's filed. It's not real property taxes. There's not a document that's filed for each and every one of us that owns property. It's not recorded at the county clerk's office. It's just a matter of law. Every year, property taxes will be assessed, and we have the right to object or protest, and then finally the taxes come due in October of that year, and then we have all the way until January 31st of the following year to pay. But the lien attaches by operation of law, so no further action needs to be taken in order for the tax lien to attach to the property. It's a super priority lien, and so it takes priority over all other liens on interest in the property, no matter what other liens or interests attach. And necessary parties, all necessary parties, when we're talking about foreclosing on a tax lien, must be involved. And so that can include spouses, guarantors on a note or deed of trust, co-owners, lenders, anyone who's obligated to pay taxes, and all others with interest in or liens on the real estate. So all the parties must be joinder to this action. If they're not, then their liens may not be wiped out. Now, an inferior lien holder to tax liens is the IRS, but they have a 120-day right of redemption. So we go through the whole process like we've seen with the other foreclosures, the notice, the personal service, the order of sale. So of course we're talking about a judicial foreclosure, notice of sale, place of sale, and then finally the sheriff's return is issued, and an order of sale, order of sale is returned by the sheriff or constable verifying the levy and sale of the property was made within the return date that was specified in the court order. And then finally, a sheriff's deed is issued and given to the purchaser, then filed in the official public records. What I was going to say about tax liens. So lenders, there are lenders out there who will take responsibility for your property tax payments if you're not able to pay them. They'll give you a loan and they'll pay your taxes, and then you just pay back that loan for the amount that they paid your taxes for. And those liens are super priority over and above a first lien holder. And so these property tax lien holders had figured out kind of a little way to get the properties of these folks whenever they secure a lien for payment of property taxes. They'll wait for the debtor to miss one payment under their new lien, and then they'll swoop in and foreclose. Then that takes out the first lien holder. And so lenders normally, especially ones that have escrow accounts, they're making tax payments at the end of the year, even before the delinquency. They're making them December normally, not waiting until January. But also they're checking the records in January to see if you don't have an escrow account, if you haven't paid your taxes, they may go ahead and swoop in and pay those and then just bill you. If they find out by maybe February 1st that you haven't paid them, because they're not wanting you to go out and do this property tax lien. Or if you do a property tax lien, if you go out and get a loan, they may try and satisfy that so that they don't have that issue. So there is a right of redemption. The owner is eligible to redeem property in a foreclosure. So if the property was residential homestead or designated as ag use, they have a right of redemption for a 2-year time frame. And then if it was a vacant tract of land, unimproved property, there's a 6-month right of redemption. And so exercising that right of redemption for residential, a prior owner or the person who lost the property can pay the purchaser the amount of the purchaser bid, recording fee for the deed, the amount that the purchaser paid for taxes, any principal and interest and costs, plus 25% of the aggregate total of those if redeemed during the first year, or all of that and 50% in the second year. Now, in return, the purchaser would execute a deed back to that owner. Now, if they're not able to locate the purchaser, then they can apply with the tax assessor and exercise their right of redemption via affidavit. And so as long as the right of redemption period has not expired, then they can reach out to the appraisal district with this affidavit confirming that they've diligently searched in the county in which the property is situated for the purchaser. They failed to find them, or confirm that the purchaser is not a resident of the county in which the property is situated, or that that they and the purchaser cannot agree on an amount of the redemption money that's due, or the purchaser refuses to give them a deed for the amount that we talked about a minute ago. So that's another way for an owner to exercise their right of redemption. Now, if the owner dies prior to the expiration of the right of redemption, then that redemption right passes to the owner's heirs at law or devisees under their will. And I knew I got ahead of myself. This is where I wanted to talk about the property tax liens. So we've already talked about that. They can, a property owner can authorize someone else to pay their taxes, get a lien. The new lender would, file a lien with the deed records, just like the first lien holder. And then that transferred tax lien may only be foreclosed judicially. And then this just talks about, again, the notice, time frame, right of redemption period. And so we're always watching out to see if there's a deed of trust in the chain of title to secure funds to advance the payment of taxes. Property owner associations, so judicially or non-judicially foreclosure availability by the property owner association, depending on provisions of the restrictive covenants in which the POA was created. Property owner association assessments can be foreclosed. There can be foreclosure action taken, but not just for fines assessed by a POA or attorney's fees incurred by the POA solely associated with fines, collecting for fines assessed by the POA. And then again, right of redemption periods. Some unusual circumstances that we often will find: a foreclosure sale held during the pendency of an open administration. That's going to be void. So if there's been a death of a debtor, then if there's an open administration and foreclosure sale has happened, the foreclosure will be deemed void. Court approval must be obtained to foreclose on the interest of a deceased debtor. And then guardianship, court approval is going to need to be needed whenever we have a foreclosure, including someone who is under guardianship. You might have a minor who has come into title for their deceased parent's property. They're not able to enter into a binding contract. They're not able to do anything on that. So we have to go to the court and follow terms of the court's process there, what they're going to require. Same thing with a incapacitated person. They're under a guardianship, so that's going to require court involvement as well. Service Members Civil Relief Act. So military personnel who purchased a home with a mortgage loan prior to entering the service cannot be foreclosed upon or without court approval during or within 90 days of the service member's military service. And then other protections exist under Texas Property Code Section 53.015 when foreclosures for dwellings where there's a service member who's on active duty or within 9 months after their service ends. So there's some protections there. And we'll work closely with underwriting counsel when we're dealing with these unusual circumstances, and of course keep you apprised so that you can all have a realistic expectation of what's going on and time frame wise for getting to the all-important closing. Bankruptcies, debtors in bankruptcies, they have an automatic stay, and so foreclosures conducted in violation of an automatic stay is going to be void. A foreclosure done without knowledge of bankruptcy, that can be reversed, for lack of a better word. The stay will continue until the case is dismissed or closed. So we'll require an order lifting stay in order to move forward with, if we're reviewing a property that's had a foreclosure, if we find anything with regard to a bankruptcy, we're going to look and make for sure that there was an order lifting stay for them to move forward with that foreclosure. Now, foreclosures can be rendered void by last-minute bankruptcy filing. So if you're working with any investors who are looking to buy properties at a foreclosure sale, they need to know that as well. Checking the bankruptcy records. The bankruptcy clerk's office opens at 9. Foreclosure proceedings normally, between 10 and 4. So they've got time, to check on that. So we want to make for sure, because that's a lot of folks, whenever they're facing foreclosure, they might reach out to an attorney and do that last minute bankruptcy filing. And so I think you can realize and understand with this presentation that we have a lot of guidelines that we have to follow. We've got checklists that we utilize whenever we're reviewing files that have had a foreclosure in the chain. And so we're reviewing the entire foreclosure process, the COVID-19 moratoriums that we talked about earlier. We've incorporated that into that search process as well. And so we've got to pay attention to all of that, as well as super priority liens, any kind of priority issues, to make for sure that whenever we do get to the point to ensure your purchaser, that they can rest assured that they are receiving a policy of title insurance, without any kind of, failure opportunity. And so I hope with this presentation, you have a better understanding of the foreclosure process. Maybe I've answered a question. If you still have questions, you're welcome to ask those now. And if I can't answer something for you, I'll definitely reach out to get an answer from one of our trusted counsel and get back to Hannah and her team to give you that answer. So does anyone have any questions?
Hey, on tax liens, what dictates the title company insuring a tax lien, a tax foreclosure? Usually I've heard between 2 years and 4 years for that to be insurable. And there's been a couple properties where it's 4 years that I've had, and then some I run title searches and say, well, you'll be good in 2 years. So what exactly is the difference?
Every transaction is different. And so I think just talking to the title agent with regard to each individual property, and of course, one thing is the residential factor. If it is a residential property or an ag use, you've got the 2 years, but I've heard that sometimes it can be extended to 4. And then if it's vacant land or unimproved land, it can be the 6 months.
If you have a cash buyer, it doesn't matter. They want to take it, you sell it to them for the deed. But if they bring in the lender, they're going to want that title policy.
Right. And so they're not going to be able to get it within that 2 years for the residential or ag, or up to 4. And then, of course, the 6 months have to have transpired for the vacant or unimproved. Any other questions? All right. Well, we've gone over a lot today, but your bellies are full. And so get out there and get more contracts and take them to Truly Title. Thank you.